The first issue I'd like to address is the defense's motion in limine submitted to the court, and it was to reduce, or it says this matter is reduced to a simple recalculation of the valuation of the plaintiff's interest by removing the discount for lack of control and adjusting figures accordingly. In this court's decision, I think the decision went well beyond that. As to a new valuation. New valuation was mentioned several times in this court's decision, not just reduced to a simple recalculation. There was also an issue.
Wouldn't that be a new valuation?
It would be under a new valuation. But the motion in limine reduced it to just a simple recalculation, and that's it. And it narrowed the issue down to that simple recalculation, and it was granted by the chancellor. The motion was granted. The other issues mentioned by this court were the 20% discount for lack of marketability, and the formula should be considered as an asset of the company. And that goes beyond the scope of the motion in limine that was granted. The second issue is the report accepted by the chancellor. The defense's report by Renee Harwell is an extremely biased report. The report valued an LLC with Jay Holeman as 100% owner. I'm not sure if it matters if she valued it as an LLC or a partnership, but what does matter is it was valued as owned 100% by Jay Holeman. This doesn't bring in equity accounts from either of the other two partners that should play a part in the valuation. Now, addressing the lack of marketability, the 20% lack of marketability. In the original trial, this court even noted Renee Harwell said that the 20% lack of marketability was to show there was not a good market for a 1/3 interest in the company. However, in the second trial, she claimed that it was a 20% lack of marketability for the entire company. Now, in her report, under her definitions, I believe her report was Exhibit 4. Definition of lack of marketability. This term has evolved as a way to distinguish minority interests in a closely held business interest. A way to distinguish minority interests. So the 20% lack of marketability was clearly for a 1/3 interest, and that never changed in the valuation. In fact, there was no new valuation. Her original valuation was just resubmitted to the court, and then I believe Exhibit 5 was the adjustment for lack of control discount. In her report, Jay Holeman was the only one that had an equity account. Holeman's equity account, for some reason I have yet to understand, was reclassified as a loan by Renee Harwell. There were no indications of a loan. There were no scheduled payments. There was no interest accrued on this account, and there was no obligation to repay. And because of that, the profit and loss statements that the company supplied to her, she modified to show a loan, which greatly devalued the company. In fact, Renee Harwell claimed that...
What additional proof did you present at trial, if any, regarding the evaluation?
That's a good question. I tried to present some proof. Anything after, any incident that happened after 2015, December 15, 2015, was disregarded by the judge. He didn't feel it was relevant. I would agree with that if both valuations used projected numbers, but both valuations used actual numbers beyond December 15, 2015, for years beyond. So I believe that anything that would affect those numbers should have been admissible in court. The judge should have considered it, which he did not. I presented evidence that Jay Holeman was taking money out of the operating account because he believed that to be his money. When I tried to press the issue, the defense objected and the judge sustained the objection. I asked if it was a personal or a business expense. and the witness wasn't allowed to answer that. In the trial, Jay Holeman claimed rents weren't being paid because the company couldn't afford it in 2015, yet there were 2 checks to an immigration attorney totaling $7,200 and it was a decision Jay Holeman made on his own, not among the 3 partners. He made it on his own. First, he claimed someone that needed a job. It made absolutely no sense that if the company can't pay rent, why would they spend $7,200 on an immigration attorney for someone that needs a job? I think the labor pool in Sevier County at the time would have been fine for someone that didn't need an immigration attorney that cost $7,200. Ms. Harwell also claimed $30,000 a year for Jay Holeman as CEO, but there was no evidence that he was actually the CEO of the company. In his own testimony, he said he's not much for business plans. He's clueless of the industry. He was never there administering the business. He was just a big picture guy. And with the question you asked before, the income from the business beyond 2015 was used in both reports. However, Ms. Harwell's report didn't include a new store that opened in 2017. The formulas were supposed to be considered as an asset of the company. Well, in Ms. Harwell's testimony, she claimed they were considered under the income approach, but she didn't use all the income. She discounted income from the second store that opened on Highway 66.
Counsel, let me ask you though. The facts you're talking about, are they after the December 15, 2015 date?
Yes.
How is that relevant to what the value was on December 15?
Because, Your Honor, both valuation experts used the numbers, the actual numbers of the business beyond December 15, 2015.
To come up with the value as of 2015?
Yes, sir. Instead of using projected numbers, they use actual numbers. But Ms. Harwell discounted the income from the second store. She claimed it wasn't known or knowable. None of the actual numbers were known or knowable, so she used numbers that weren't actually known or knowable. The formulas in the income approach, the income from the second store should have been used because those formulas were used to support the second store, the same products. In fact, everything was produced at the first store using those formulas and just shipped to the second store for sale. It was basically an outlet. So, but she discounted those numbers from that second store using those formulas. Now, okay, we touched on that. Okay, the equity account for Boesch or Frazier. The statute 61-1-401A. Each partner is deemed to have an account that is, 1, credited with an amount equal to the money plus the value of any other property, net the amount of any liability the partner contributes to the partnership, and the partner's share of the partnership profits. There was no equity account for Boesch or Frazier. The formulas that were put in should have been in that equity account that was property put towards the business. The 18 months of sweat equity was property put towards the business. This wasn't considered in Ms. Harwell's valuation. There was no equity account for either of the other 2 partners. And the contribution of Jay Holeman that was considered a loan, once again, there was no evidence that it was a loan, and even in the statute 61-1-401D, partnership shall reimburse a partner for an advance to the partnership beyond the amount of capital the partner agreed to contribute. Section E, a payment or advance made by a partner which gives rise to an obligation under subsection C and D constitute a loan to the partnership which accrues interest from the date of the payment or advance. Now, Mr. Holeman, according to Renee Harwell, only put up $267,000, well below his $300,000 agreed contribution. So I don't see under the statute how that could be considered a loan. It didn't even equal his agreed contribution. I believe my time is up for.
Okay, thank you. You have your time for rebuttal. We'll hear from the appellee.
Thank you. I do not anticipate using my entire time, so let me extend my condolences to the court and to the staff for Judge Zano's passing. I also am a graduate of Notre Dame, but it's a high school down in Chattanooga. It's not the university. I'm afraid their academic standards deterred me from making an application to that institution even back when the dinosaurs roamed. But in any event, I'm sure he was an extraordinary colleague and friend of many of you. First, if you would, let me address. Well,
This has not been a good morning for me. I'm taking my apologies. Go ahead, Counsel.
As the court is well aware, this court previously upheld the trial court's ruling in the original trial in this case, with the exception of the proper application of TCA section 61-1701 with the statute of dissolution of partnership, and ordered a rehearing on that valuation. That, in fact, occurred on September 28, 2021, before Chancellor Fogarty, at which time the appellant and the appellees had the opportunity to put on proof. At that time, at the conclusion of the proof, the judge awarded the appellant $40,063.80, which was beyond the original $23,000 award that was in the original hearing. That was based upon the testimony of the expert witnesses, the record as a whole. Let me first address the motion in limine. The appellant has failed to show what exactly he's claiming was excluded, and then what was excluded resulted in some sort of harm to him. And in other words, what substantial right was affected to the appellant by the exclusion of evidence. He hasn't shown any of that. To this day, I don't know exactly what he's talking about that somehow got excluded that affected his case in any respect. I would suggest to the court that the record would show that the motion in limine was filed by me only because the pre-hearing filing suggested that Mr. Boesch wished to try the entire case again, which was not before the court. It was the valuation that was to be retried, not the other issues. And I'll also suggest to this court that the record would reflect that Chancellor Fogarty had allowed a good deal of latitude and discretion in allowing into evidence through Mr. Boesch a good deal of extraneous testimony and exhibits that I think did not really bear on the central issue. In any event, I think that issue is a non-issue. There was no offer of proof. There was no demonstration of what was excluded and how it harmed. There's nothing before this court to reflect that. On the expert testimony, really, which is kind of the central testimony, both parties presented their experts again, and the appellant presented Mr. Parker again, who, instead of taking his original report and adjusting as necessary to the directions of this court, appeared to have conjured up a whole new evaluation. And in fact, conjured up a whole new evaluation for the appellant. They gave him even more money. And in doing so, he somehow used what I would call a evaluation crystal ball, and somehow took the generation of revenue from business operations that did not exist or were not known or knowable on December 15th of 2015. In other words, a whole new operation, a whole new shop in which Mr. Boesch had no activity or interest whatsoever, took those numbers, applied them backwards, and came up with some astronomical figure of, I think it was something like $372,000, asserting respectfully, absurdly, that was Mr. Bosch's valuation, 1/3 interest in this business as of December 15th of 2015. If you take that number and multiply it by 3, it's $1.1 million. He valued that business that had been in operation for a little over 3 months and hadn't remotely turned a profit. And if that had been liquidated, would have been in the negative.
Mr. Bosch says that your expert used numbers or information from beyond the date of valuation. Is that correct?
That is correct. But what she did, and she explained, and only to a limited extent, the proper way to do it is to take the time, December 15, 2015, and determine what may be projected numbers. But she indicated, just for the matter of convenience, so that there would not be a dispute, she took the real numbers of that one store for a period of time, and I can't remember what it was, maybe it was a year, but whatever, and used the real numbers as a matter of convenience, because even though technically that may not be correct, it could be without dispute, because we're taking real numbers. That favored Mr. Bosch, by the way, because if they had projected, as we know, 4 out of 5 new businesses failed. But she went ahead and took the real numbers. They did keep their doors open and just applied those. That was really a matter of convenience, and I think that Mr. Parker did that as well. The problem is, what Mr. Parker did is that he went and took numbers well beyond that. The first hearing, he took some arbitrary date, I think August of 2017 is his cutoff date, and in his new report, he went even beyond that and used all kinds of numbers from another operation that opened up on Highway 66 long after Mr. Bosch was gone. So he just went, for sake of a better term, kind of crazy on, numbers, and used a crystal ball and applied them retroactively. So that's how that happened.
Let's use a different term. All right?
Yes.
No, we're going quite crazy to what Mr. Bosch did.
Okay. I couldn't come up with a better term.
I understand.
But to me, it would be excessive. Ms. Harwell, on the other hand, in her testimony, took her original report, which was thorough, very well thought out, very detailed, and then considered it and revised it based upon this court's instruction and the specific requirements of the code provision. I asked her specifically, and she pointed specifically to her report to confirm that the discount for marketability was as the business as a whole, despite what Mr. Bosch says. She always did that and affirmed that's what she did that in the last hearing. Because you have a small business like this that's not on the open market, that hasn't turned a profit, that has essentially 3 partners, has there's just not much of a market on the business as a whole. So she did that. She also made it clear and affirmed in her testimony that certainly the value of the formulas were included in her valuation of the business, which she did. And the third thing she did, which was directly on point, is that she removed the lack of control from Mr. Bosch, took that out of her prior report, which resulted in an adjusted value increase to Mr. Bosch to a principal amount of about $35,000, and then with the interest it came up to about $40,000. So she did every bit of that, and there has been nothing to indicate that the court's acceptance of that is in any way an abuse of discretion. I think the court will see that we were careful and she was careful to follow the court's opinion, review the statute, adjust her report accordingly, and then therefore made an adjusted figure to the benefit of the appellant. The last thing I would mention is that, and the appellant didn't argue this, but he seemed to contest the determination of prejudgment interest. I would just suggest to the court that Mr. Bosch, the appellant, provided no evidence of what would be appropriate prejudgment interest. We did. We offered testimony through Ms. Harwell as to what would be the appropriate interest, and we did that under the guise of the applicable law. And if I may, She went through kind of the gamut of what interest rates are. It's a pretty broad range. But then I said, okay, based on that information, and I realized we don't have anything that directly applies to this situation. It's a little unique. So could you help the court in providing a range of what would be a reasonable interest rate, understanding the standards as applicable to the law to compensate the plaintiff for loss of funds to which he or she was legally entitled, but not to penalize the defendant for wrongdoing, which I believe to be the standard on prejudgment interest. And she said, well, your low would be your savings account rate, money market rate, half of 1%. Your high would be what you can borrow your money at, long-term loan purposes. You're looking at 3.5%, somewhere in that range. So 0.5% to 3.5%, and the judge set the interest rate at 2.5% prejudgment on what Mr. Boesch was entitled to at the time of dissolution. That's all I have. Any questions? Thank you.
I hear that. Thank you. We'll hear from you, Mr. Boesch, for rebuttal.
Your Honors, I'd like to address the testimony of Julie Holeman. The leases that were supplied, they were Exhibit 2, show $7,500 in lease for Newport Highway, and I believe $24,500 for Highway 66. These leases were produced and sent during discovery. They were introduced at trial. Julie Holeman testified that these lease amounts were not accurate, that they were actually profits being funneled to Jay Holeman for tax savings. And Vicki Frazier, Richard Frazier, one of the partners' wives, was drawing an exorbitant salary, $150,000 a year, for doing some book work and some retail work. And Julie Holeman also confirmed that this wasn't actual salary. This was money being funneled to Richard Frazier because he was on Social Security and couldn't earn more than $1,500 a month. She confirmed that the QuickBooks reflected this. They took these profits that were paid out and listed them in QuickBooks as expenses. So that would most definitely affect the profit and loss statement that Ms. Harwell used for her report. I mean, we're talking a couple $100,000 a year. So that was some of the evidence that wasn't considered because judge claimed that happened after December 15th, 2015, but this did affect the actual numbers of the business, the numbers that were used in both reports. I'd like to address the interest rate. Mr. Mansfield, and I believe this was very misleading. We don't have anything that directly applies to this situation. Not only do we have something that directly applies to this situation, we have this exact situation in the form of Renee Harwell's report. Her report, page 39, required rates of return. This wasn't a loan. Everything they presented was for a loan, interest rates. This was an investment in a small business. I had the statute, but well, I thought I wrote it down, but apparently I didn't. It's for the, I have it here. Yes. Maximum effective rates of prejudgment interest so awarded shall be the same set as by the section of the particular category of transaction involved. Once again, this transaction wasn't a loan, it was an investment in a small business. And according to Ms. Harwell's required rates of return for investment in a small business, we're looking at 23% to 25.5%. Her testimony at trial, my comment, why would anyone invest in a small business for less than 10.5%? So that was the defense's own evidence they submitted as far as interest rates for the prejudgment interest. Before my time is up, Your Honors, I'd like to kind of take an objective look at this business beyond the profits that were funneled into the owners and treated as as expenses, which greatly affects the profit and loss reports. If you look at this business, there was over $250,000 in cash invested, $300,000 worth of formulas, 18 months of sweat equity by two partners. And the business is supposed to be valued as a whole, well-informed buyer, well-informed seller, under no compulsion to sell. Is it reasonable to think any person would sell this business that made $170,000 in revenue in the first 4 months, would actually sell this business for $104,000? I believe that's completely ridiculous. The business in 4 months, $170,000 in revenue. And even if you take a look forward, which would be looking back on the valuation reports, even though Renee Harwell in her report claimed 2016 was a loss, the tax returns for the business claimed $170,000 in profit. And that's even after the leases and salary payments were treated as expenses instead of profits. $170,000 in profits. And this business would actually sell for $104,000. It just makes absolutely no sense.
Your time's expired, sir. Of course, thanks to both sides. We appreciate your arguments and your briefs on this. Thank you.